Good afternoon. This is Ron Mickens. Here we go. You know the deal. Fraud upon the court. The truth is in the details. So you got to hang in there with me. This is part B of our right to travel memorandum of law. Part B of our right to travel. The truth is in the details. So, Roman number 3. Definitions. In order to understand the correct application of the statute in question, we must first define the terms used in connection with this point of law. As will be shown, many terms used today do not, in their legal context, mean what we assume they mean, thus resulting in the misapplication of statutes in the instant case. Automobile and motor vehicle. There is a clear distinction between an automobile and a motor vehicle. An automobile has been defined as the word automobile connotes a pleasure vehicle designed for the transportation of persons on a highway. American Mutual Liberty Insurance Company versus Chaput. While the distinction is made clear between the two, as the courts have stated, a motor vehicle or automobile for hire is a motor vehicle other than an automobile stage used for the transportation of persons for which remuneration is received. The term motor vehicle is different and broader than the word automobile. The distinction is made very clear in United States Code, Title 18, Section 31. Motor vehicle means every description or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers and property. Used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other considerations, or directly or indirectly in connection with any business or other undertaking intending for profit. The term travel is a significant term and is defined as the term travel and traveler are usually construed in their broad and general sense so as to include all those who rightfully use the highways viatically and who has occasion to pass over them for the purpose of business, convenience, or pleasure. Traveler, one who passes from place to place, whether for pleasure, instruction, business, or health. That's Bovier's Law Dictionary. Travel, to journey, or to pass through or over as a country district, road, etc. To go from one place to another, whether on foot or horseback, or in any conveyance, as a train, an automobile, carriage, ship, or aircraft. Make a journey. Therefore, the term travel or traveler refers to one who uses a conveyance to go from one place to another and included all those who use the highways as a matter of right. Not that, notice that in all these definitions, the phrase for hire never occurs. This term, travel or traveler, implies by definition one who uses the road as a means to move from one place to another. Therefore, one who uses the road in the ordinary course of life and business for the purpose of travel and transportation is a traveler. Driver. The term driver in contradistinction to traveler is defined as driver, one employed in conducting a coach, carriage, wagon, or other vehicle. Bovier's Law Dictionary. Notice that this definition includes one who is employed in conducting a vehicle. It should be self-evident that this person could not be traveling on a journey, but is using the road as a place in the conduct of business. Operator. Today, we assume that a traveler is a driver and a driver is an operator. However, this is not the case. It will be observed from the language of the ordinance that a distinction is to be drawn between the terms operator and driver. The operator of the service car being the person who is licensed to have the car on the street in the business of carrying passengers for hire, while the driver is the one who actually drives the car. However, in the actual prosecution of business, it was possible for the same person to be both operator and driver. To further clarify the definition of an operator, the court observed that this was a vehicle for hire and that it was in the business of carrying passengers. This definition would seem to describe a person who is using the road as a place of business, or in other words, a person engaged in the privilege of using the road for gain. This definition then is a further clarification of the distinction mentioned earlier, and therefore traveling upon and transporting one's property upon the public roads as a matter of right meets the definition of a traveler. Using the road as a place of business as a matter of privilege meets the definition of a driver or an operator, or both. Traffic. Having defined the terms automobile, motor vehicle, traveler, driver, and operator, the next term to define is traffic. Traffic thereon is to some extent destructive. Therefore, the prevention of unnecessary duplication of auto transportation service will lengthen the life of the highway or reduce the cost of maintenance. The revenue derived by the state will also tend toward the public welfare by producing, at the expense of those operating for private gain, some small part of the cost of repairing the wear. Note, in the above, Justice Tolman expounded upon the key of raising revenue by taxing the privilege to use the public roads at the expense of those operating for gain. In this case, the word traffic is used in conjunction with the unnecessary auto transportation service, or in other words, vehicles for hire. The word traffic is another word which is to be strictly construed to the conducting of business. Traffic, commerce, trade, sale, or exchange of merchandise, bills, money, or the like. The passage of goods and commodities from one person to another for an equivalent in goods or money. Barbier's Law Dictionary. Here again, notice that this definition refers to one conducting business. No mention is made of one who is traveling in his automobile. This definition is one of who is engaged in the passing of a commodity or goods in exchange for money, i.e. vehicles for hire. Furthermore, the word traffic and travel must have different meaning, which the courts recognize. The difference is recognized in ex parte dicey. In addition to this, cabs, hackney coaches, omnibuses, taxicabs, and hacks, when unnecessarily numerous, interfere with the ordinary traffic and travel and obstruct them. The court, by using both terms, signified its recognition of a distinction between the two. But what was the distinction? We have already defined both terms. Now, to nail the matter down, the word traffic is manifestly used here in secondary sense and has reference to the business of transportation rather than to its primary meaning of interchange of commodities. That's Allen versus City of Bellingham. Here the Supreme Court of the State of Washington has defined the word traffic in reference to business and not to mere travel. So it is clear that the term traffic is business related and therefore it is a privilege. The next result being that traffic is brought under the police powers of the legislature. The term has no application to one who is not using the roads as a source of income or a place of business. License. It seems only proper to define the word license as the definition of this word will be extremely important in understanding the statutes as they are properly applied. The permission by competent authority to do an act which, without permission, would be illegal, a trespass, or a tort. Leave to do a thing which licensor could prevent. In order for these two definitions to apply in this case, the state would have to prove the position that the exercise of a constitutional right to use the public roads in the ordinary course of life and business is illegal, a trespass, or a tort, which the state could then regulate or prevent. This position, however, would raise constitutional questions, as this position would be diametrically opposed to fundamental constitutional law. In the instant case, the proper definition of a license is a permit granted by an appropriate governmental body, generally for consideration to a person, firm, or corporation to pursue some occupation or to carry on some business which is subject to regulation under the police power. This definition will fall more in the line with the privilege of carrying on business on the street. Most people tend to think that licensing is imposed by the state for the purpose of raising revenue, yet there may well be more subtle reason contemplated. For when one seeks permission from someone to do something, he invokes the jurisdiction of the licensor, which in this case is the state. In essence, the license may well be seeking to be regulated by the licensor. A license fee is a charge made primarily for regulation, with the fee to cover costs and expenses of supervision or regulation. The fee is the price, the regulation or control of the licensee, which is the real aim of the legislation. Are these licenses really used to fund legitimate government, or are they nothing more than a subtle introduction of police power into every facet of our lives? Have our enforcement agencies been diverted from crime prevention, perhaps through no fault of their own, now busying themselves as they check our papers to see that all are properly endorsed by the state? And which legislative section will it be before we are forced to get a license for lawnmowers, generators, tillers, and air conditioners? Or before women are required to have a license for their blenders or mixers? All have motors on them, and the state can always use the revenue. At what point does the steady encroachment into our liberty cease? Police powers. The confusion of the police power with the power of taxation usually arises in cases where the police power has affixed a penalty to a certain act or omission to act, or where it requires license to be obtained and a certain sum be paid for certain occupation. The power used in the instant case cannot, however, be the power of taxation, since an attempt to levy a tax upon a right would be open to constitutional objection. Each law relating to the legitimate use of police power must ask three questions. Is there threat and danger? Does a regulation involve a constitutional right? Is the regulation reasonable? Bovier's Law Dictionary. Police power. When applying these three questions to the statute in question, some very important issues are clarified. First, is there a threat and danger in the individual using his automobile on the public highways in the ordinary course of life and business? The answer is no. There is nothing inherently dangerous in the use of an automobile when it is carefully managed. The guidance, speed, and noise are subject to a quick and easy control. Under a competent and considerate manager, it is as harmless on the road as a horse and buggy, possibly more so. It is the manner of managing the automobile, and that alone, which threatens the safety of the public. The ability to stop quickly and to respond quickly to guidance would seem to make the automobile one of the least dangerous conveyances. The automobile is not inherently dangerous. Broadwater. Blair versus Broadwater. To deprive all persons of the right to use the road in the ordinary course of life and business because one might in the future become dangerous would be a deprivation not of only the right to travel, but also the right to due process. Next, does the regulation involve a constitutional right? Okay. This question has already been addressed and answered in this brief and need not be reinforced other than to remind this court that this citizen does have the right to travel upon the public highways by automobile in the ordinary course of life and business. It can therefore be concluded that this question does involve a constitutional right. The third question is the most important in this case. Is this regulation reasonable? Is this regulation reasonable? The answer is no. It will be shown later in regulation that this licensing statute is oppressive and could be effectively administered by less oppressive means. Although the 14th Amendment does not interfere with the proper exercise of the police power in accordance with the general principle that the power must be exercised so as not to invade unreasonably the rights guaranteed by the United States Constitution, it is established beyond any question that every state power, including the police power, is limited by the 14th Amendment and by the inhibitions there imposed. Moreover, the ultimate test of the propriety of police power regulation must be found in the sense it operates as a bulwark to limit the field of the police power to the extent of preventing the enforcement of statutes in denial of rights that the Constitution protects. See Parks versus State. With regard particularly to the U.S. Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state police authority. Canady versus the Union Sewer Pipe Company. The police power of the state must be exercised in subordination to the provision of the U.S. Constitution. Penn Eastern Pipeline Company versus State Highway Commission. It is well settled that the constitutional rights protected from invasion by the police power include rights safeguarded both by express and implied prohibition in the Constitution. Teehee versus Osborne. As a rule, fundamental limitations of regulations under the police power are found in the spirit of the Constitution, not in the letter, although they are just as efficient as if expressed in the clearest language. Medlow versus City of Milwaukee. As it applies in the instant case, the language of the Fifth Amendment is clear. No person shall be deprived of life, liberty, or property without due process of law. As has been demonstrated, the courts at all levels have firmly established an absolute right to travel. In the instant case, the state, by applying commercial status to all entities, natural and artificial persons alike, the legislature has deprived this free and natural person of the right of liberty without cause and without due process of law. The essential element of due process of law, notice and an opportunity to defend. Simon versus Kraft. Yet, not one individual has ever been given notice of the loss of his/her right before signing the license/contract, nor was the citizen given any opportunity to defend against the loss of his/her right to travel by automobile on the highway in the ordinary course of life and business. This amounts to an arbitrary government deprivation of liberty. There should be no arbitrary deprivation of life or liberty. Barbier versus Canady. The right to travel is part of the liberty of which a citizen cannot deprive without due process of law under the Fifth Amendment. The right was emergent as early as the Magna Carta. Kent versus Dews. The focal point of this question of police power and due process must balance upon the point of making the public highways a safe place for the public to travel. If a man travels in a manner that creates actual damage, an action in law would be the appropriate remedy for recovery of damages. The state could then also proceed against the individual to deprive him of his right to use the public highway. This process would fulfill the due process requirement of the Fifth Amendment while at the same time ensuring that rights guaranteed by the Constitution for the United States of America and the respective state constitution would be protected for all. But unless or until harm or damage, that's a crime, is committed, there is no cause for interference in the private affairs or actions of a sovereign citizen. One of the most famous and perhaps the most quoted definitions of due process of law is that of Daniel Webster in his Dartmouth College case, in which he declared that due process means a law which hears before it condemns, which proceeds upon inquiry, and renders judgment only at the trial. State versus Strasbourg. Somewhat similar in the statement that is a rule as old as the law that no one shall be personally bound until he has had his day in court, until he has been duly summoned to appear and has been afforded an opportunity to be heard. Judgment without such summons and opportunity lacks all the attributes of a judicial determination. It is judicial usurpation, and it is oppressive and can never be upheld where it is unfairly administered. The futility of the state's position can be most easily observed in AD 1959, Washington Attorney General's opinion on a similar issue. Under its power to regulate private uses of our highways, our legislature has required the motor vehicle operator be licensed. Undoubtedly, the primary purpose of this requirement is to ensure, as far as possible, that all motor vehicle operators will be competent and qualified, thereby reducing the potential hazard or risk of harm to which other users of the highway might otherwise be subject. But once having complied with the regulatory provision by obtaining the required license, our motorists enjoy the privilege of traveling freely upon the highway. This alarming opinion appears to be saying that every person using an automobile as a matter of right must give up the right and convert the right into a privilege. This is accomplished under the guise of regulation. This statement is indicative of the insensitivity, even the pretended ignorance of the government to the restrictions placed upon government by and through the several constitution. That legal proposition may have been able to stand in 1959. However, as of 1966, in the United States Supreme Court decision in Miranda clearly demonstrated that even this weak defense of the state's action must fail. Thus, the legislature does not have the power to abrogate the citizen's right to travel upon the public roads by passing legislation forcing the citizens to waive his right and convert that right into a privilege. Furthermore, we have previously established that this privilege has been defined as applying only to those who are conducting business in the streets or operating for hire vehicles. The legislature has attempted by legislative fiat to deprive the citizens of his right to use the roads in the ordinary course of life and business without affording the citizens the safeguard of due process. This has been accomplished under supposed power of regulation. Okay, ladies and gentlemen, the memorandum of law is extensive. We have a constitutional God-given right to travel. Listen now, I'll be back. Stay with me. Okay, in the words of Allah Beware, the way you right wrong is to shine the light of truth upon them. The truth is in the detail. I'll talk to you later. Bye.